So we're going to continue from where we left off in the mysteries of the Solemn Brotherhood of the East. We're dealing with chapter 18. Yahshua passes the fifth degree, adept degree, passes the fifth adept degree, heroism. The sacred temple groves were rich in statues, monuments, and shrines where Yahshua loved to walk and meditate. And after he had conquered self, he talked with nature in these groves for 40 days. And then the guide took chains and bound him hand and foot and cast him into a den of hungry beasts, of unclean birds and creeping things. The den was dark as night. The wild beasts howled. The birds in fury screamed, and reptiles hissed. And Yahshua said, "Who is it that did bind me thus? Why did I meekly sit to be bound down with chains? I tell you, none has power to bind the human soul. Of what are fetters made?" When you look at fetters, you'll see that's just a chain or a constraint. What are fetters made? And in his might, he rose, and what he thought were chains were only worthless cords that parted at his touch. And then he laughed and said, "The chains that bind men to the carcasses of earth are forged in fancy shops and are made of air and welded in illusion's fires. If man will stand and use the power of will, his chains will fall like worthless rags." Worthless rags. Willpower. For will and faith are stronger than the stoutest chains that men have ever made. And Yahshua stood erect among the hungry beasts and birds and said, "What is this darkness that envelopes me? What is this darkness that envelopes me? 'Tis but the absence of light." Yahshua phrases a question: what is light? "'Tis but the breath of Allah vibrating in the rhyme of, or in the rhythm of rapid thought." And we know based on previous lessons, light is truth. So was it really dark? Was it really howling beasts, literally? Or was it people that lack light? "'Tis but the absence of light." What is light? "'Tis but the breath of Allah vibrating in the rhythm of rapid thought." Remember, light and truth is a different vibration. Vibration is when we talk vibration, we're talking different rates of vibration. Vibrating faster, vibrating slower. What so we know truth is a high vibration, right? And then he said, "Let there be light," or "Let there be truth." And with a mighty will, he stirred up the ethers. He stirred the ethers up, and their vibrations reached the plane of light. And there was light. The darkness of that den of night began the brightness of a newborn day. Just like that is light now. Transmutation, magician, different mindset, discipline. And then he looked to see the beasts and birds and creeping things. Lo, they were not. And then Yahshua asked, of what is soul afraid? Fear is the chariot in which man rides to death. And then he finds himself with the chamber of the dead. He learns that he has been deceived. His chariot was a myth, and death a fancy child. But someday all men's lessons will be learned, and from the den of unclean beasts and birds and creeping things, he will rise to walk in light, or walk in truth. And Yahshua saw a ladder made of gold on which he climbed, and at the top of the white-robed priest awaited him. Again, he stood before the council bar. Again, no word was said. And again, the hierophant, or the magician, or the high priest, reached for his hand in bliss. He placed Yahshua's hand, another scroll, right? And on this was written heroism. The Logos, which we know is just Yahshua, he's also he's the Logos now because he's activated the Christ at this point in these lessons. The Logos had encountered fear and all his phantom hosts, and in the conflict he achieved victory. Conflict with who is the question. I want to open the floor for just light thoughts on this before we transition in Islam and Happy Holy Day to Mataza Maji El and the brother Blaze Lehman. Happy Holy Day on this day of Venus. Hope y'all been having a beautiful day. So I'm gonna open the floor. Just light thoughts on this before we transition to the court procedure where we left off last week, the last session. Anybody have any thoughts on this segment as far as Yahshua's lessons? Yahshua passes 5th degree lessons, heroism. Any thoughts?
Hey, how you doing, brother?
Islam, peace and love, brother.
Peace and love, brother. Is this a chapter in the Holy Quran that you're reading from?
In some Circle 7 Qurans, it would be like a sequel. It'll be all in one book, depending on what you have, or it'll be in its own book, and it's called The Mysteries of the Silent Brotherhood of the East.
Okay. Yeah, I was going through the pages of mine. I couldn't locate it at the time. But now this is man, I'm glad I walked in on this section, man. This is beautiful right here. I don't have anything to expound on. Just keep shining that light, man. Keep going, brother. I'm here for it.
Islam. Anybody else had any thoughts? All right, so we're going to transition to where we left off. Wednesday, court procedure, etiquette. You call it etiquette. The complaint and 0 factor. A complaint is, in legal terminology, is any formal legal document that sets out the facts and legal reasons or cause of action or cause and effect that the filing party or parties, plaintiff / movements or affiants, believe are sufficient to support a claim against the party or parties against whom the claim is brought, or the defendants, that entitles the plaintiff to a remedy, either money, damages, or injunctive relief. The complaint must be based on incident, or what I would like to call a 0 factor, meaning what exactly caused the injury which poised you to file the complaint. This initial injury is the issue of law upon which your issues of facts have standing. Due process law, law in its regular court of administration through courts of justice. Due process of law in each particular case means such an exercise of the powers of the government as the settlement's maxims of law permit and sanction. Maxims of law, once again, we talked about this Wednesday. I put it out there. The 10 maxims of law is something everybody should know about. And then you just need to know about, constitutional, contract law. They all kind of go hand in hand. Just wanted to throw that out there. Those maxims prescribe for the class of cases to which the one in which question belongs. Whatever difficulty may be experienced in giving to those terms of definition, which will embrace every permissible exertion of power, affecting private rights, and excluding such as forbidden, there can be no doubt of their meaning when applied to judicial proceedings, right? The law, just go straight to the law. Article whatever, clause whatever, section whatever. Whatever you're trying to do to sustain your point, bring the proof. What's the proof? Case law. What's the proof? Resolutions, public acts, things that have been decided. Use that and make it apply to whatever your situation is. They then mean a course of legal proceedings according to those rules and principles which have been established in our system of jurisprudence for the enforcement and protection of private rights. To give such proceeding any validity, we must be a tribunal, competent by its constitution, that is, by the law of its creation, to pass upon the subject matter of the suit, and if that involves merely a determination of the personal liability of the defendant, he must be brought within its jurisdiction by service of process within that state, or his voluntary appearance. And that was actually from a quote from a court case, Penor versus Neff. Due process of law implies the right of the person affected thereby to be present before the tribunal, which pronounces judgment upon the question of life, liberty, or property in its most comprehensive sense, to be heard by testimony or otherwise, and to have the right of controverting by proof every material fact which bears on the question of right in the matter involved. If any question of fact or liability be conclusively presumed against him, this is not due process of law. And once again, I like to, the Fourth and Fifth Amendment together spells out due process law, just to make it simple. You look at the Fifth Amendment, look at the Fourth Amendment, put those things together, it's going to tell a story. What's the story going to say? Oh, an injured party felt that they were injured by you, or you injured their property. That injured party means a human being was like, oh, okay, I'm gonna fill out this affidavit and make a claim. The claim is made, and then it goes to a grand jury. Then it's an indictment process. Then there's a warrant or summons issued. And then that warrant or summons is attached to a oath or affidavit that got sworn, that somebody got sworn in or took oath. And then it's describing the specific place to be searched. If anything like that, if they're talking about, I need to see something, right? So that's, that would be due process and 101, due process 101, call it like that, elementary, right? These phrases in the Constitution do not mean the general body of law, common in statute as it was at the time the Constitution took effect. for that would seem to deny the right of the legislator or amend or repeal the law. They refer to certain fundamental rights, which that system of jurisprudence, of which ours is a derivative, has always recognized. That was Brown versus Levy. And whoever doesn't know jurisprudence, that's the science of the law. Due process of law is used in the Constitution, cannot mean less than a prosecution or suit instituted and conducted according to the prescribed forms and solemnities of asserting guilt or determining the title of property. Emmer versus Conner. And once again, jurisprudence, another synonym or a synonymous, what's synonymous to jurisprudence would be law of the land. And when you look up jurisprudence on your own and look it up on maybe 3 different search engines, get like 5 different definitions of jurisprudence, and you'll see what I'm saying. So law of the land or jurisprudence, due course of law, and due process are all synonymous. And I wasn't even looking ahead. I just used the word synonymous. I'm reading this with y'all. See how I pop out? That's divine. Law of correspondence. People versus Skinner. Stay versus Rossi. Whenever you see court cases with commas and talking, and then it goes to the other court case, elements of both those cases. When you look at the transcripts, it's going to talk about law of the land due process was asserted by one of these party members. Typically, in the State versus Rossi, I would presume it was Rossi. Talking about law of the land due process. If I was to take a wild guess. But due process and judicial proceedings are not necessarily synonymous with due process. Pennsylvania Publishing, Pennsylvania Publication versus Pennsylvania, etc. The essential elements of due process of law are notice and opportunity to be heard, and to defend an orderly proceeding, adapt to nature of case, and the guarantee of due process requires that every man have protection of day in court and benefit of general law, right? General law, jurisprudence, due process, constitution, treaty, rights of indigenous people. This is all common law, commonly known law, basic law, jurisprudence. Daniel Webster defined this phrase to mean a law which hears before it condemns, which proceeds on inquiry and renders judgment only after trial. Wichita Council, etc. He says about 4 cases that correlate. This constitutional guarantee demands only that law shall be unreasonable, arbitrary, or capricious, and that means selected shall have real substantial relation to object. Now here's an example. In this example, we're dealing with a charge, assault, date, John Smith punches Stevenson in the face, right? All right, so let's deal with the effects, the punch in the face, right? So the effect, intent to sue. So we're talking about due process and the channels of how due process works. Punch in the face, intent to sue. Stephen Johnson puts in writing a via signed affidavit, a detailed account of what happened on 11/29/17, the punch in the face, right? As well as proof that he in fact was punched in the face by John Smith. Stephen Johnson is also required to properly name John Smith within his affidavit of claim being made against him, as well as properly identifying himself as the injured party. or the corpus delicti, which we know in Latin as injured party, right? We look in the law dictionary, fourth edition, right? And submit the signed affidavit to a competent court with prescribed jurisdiction. We're going through due process. We're going through it. We're going through the channels. But what's supposed to happen if somebody's saying you injured them, a human being? 2, judicial review and indictment. The written statement of facts affidavit is reviewed by a grand jury, administrative clerks, or magistrates to ensure that a legitimate issue is presented before placing the accused, John Smith, on notice of the indictment, presentment of the accusations being made against him. So if no grand jury came up with an indictment and they just saying like, oh, here, you did something wrong, here's the date, you got to show up. They skip some steps. Law, due process is being violated. A grand jury is a body of jurists empowered to conduct official proceedings and investigate potential criminal conduct. A grand jury is vested with the power of determining whether or not criminal charges should be brought before the court. Sherry versus Cullen, famous court case. For there to be an injury, must be an injured party.
Hey, brother, I got to, if I may interrupt, I have a question.
Yeah, Islam, go ahead.
Okay, so I'm not too familiar in law, but you said there were some steps missed, and they violated. What did they violate? You said the due process. I'm guessing that you're saying the formality in which it's supposed to go wasn't done correctly.
Right.
Um,
Right. What formality is that?
That's my question. I guess that's my question.
Okay. And so the formality would be that it was no grand jury. In the example that I'm giving, that most times they're going to just say, you did something wrong, show up here. They're not, there's no indictment papers or anything like that stating that an injured party said you did X, Y, Z, and then that affidavit, this person took this affidavit and it was reviewed by a grand jury, and then after that it was ruled that, okay, based on this affidavit and the proof that this human being, it might be a big black eye.
Okay. I see what you're saying. So there's supposed to be some form of investigation, and let's say, for instance, if I was the accused, I'm supposed to receive some form of documentation that shows that they went through the correct process before they subpoena me to court.
Right.
Is that correct?
Correct.
Okay.
And that's called due process. That's called due process. What you just said in law is called due process. Yep.
Okay. Yes, sir. Yes, sir.
That's law. Upon review, once the grand jury sees the accusations being made in the affidavit, determining that yes, assault is a crime, and indictment or presentment is then sent to the accused, i.e. John Smith, informing him of the nature of the crimes and or accusations being made against him, as well as Stephen Johnson's intent to sue, providing John Smith the opportunity to prepare a defense for himself, right? So this is another reason why due process is important, because we're talking about, the right to discovery, so you can even prepare a defense, right? And Sixth Amendment, right? You got the right to face your accuser when you look in the Sixth Amendment of the Constitution, or the Sixth Bill of Rights, right? So arraignment, we're transitioning, right? Arraignment. The next step, arraignment is a formal reading of a criminal charging document in the presence of the defense to inform the defendant of the charges against him. In response to arraignment, the accused is expected to enter a plea. Now let's look up the law definition of arraign. In criminal practice, to bring a prisoner to the bar of the court to answer to the matter charged upon him in the indictment. The arraignment of the prisoner consists of calling upon him by name and reading to him the indictment and demanding of him whether he be guilty or not and entering his plea. Then it goes down to Old English law. To order or set in order, to conduct in an orderly manner, to prepare for trial, to arraign and assess was to cause the tenant to be called to make the plaint, and to set the cause in such order as the tenant might be enforced to answer thereunto. Preliminary hearing. 840. I'm just going to read this page and I'm going to yield the floor to the Empress, Lacey. Preliminary hearing. Within some criminal justice systems, a preliminary hearing, preliminary examination, evidentiary hearing, or probable cause hearing is a proceeding after a criminal complaint has been filed by the prosecutor to determine whether there is enough evidence to require a trial. Preliminary, introductory, initiatory, proceeding temporary and provisional as preliminary examination, injunction, articles of peace, etc. I'm actually stop right here. We'll pick it up Wednesday with preliminary and continue. I'm gonna yield the floor first for just any comments and thoughts on this segment, and then after that, well, I'm gonna yield the floor to Empress Lacey so she can do her dissertation, of which she digested it more as tactical. So I'm gonna open the floor.
You know what I was wondering is, you know how sometimes the people don't want to press charges anymore, but the district attorney decides to pick up the case and further prosecute you? If you're in your natural person, they can't do that then, right? Because there's no injured party to make a claim.
That's the key. It must be an injured party to
But
even kick it off.
what would the district attorney say the injured party is? The city of Los Angeles or something like that?
The municipal, the municipality of LA, the municipality of Carson, Gardena, whatever they're calling it, right? The city.
So they would want to continue to prosecute based on that, saying that the city is the injured party.
That's where they're gonna go because most people don't know law, so they go, yeah, that's what's happening. That's what's going on. The people don't know better, so they're getting away with saying this. Because when you remember, when you get the charter for any city, it's gonna say, for instance, the city of Gardena or Carson or Long Beach, whatever. It's gonna say the city of is the DBA basically, and it's a municipal corporation
Versus
known as, in all caps, the city of whatever, all charters. You look it up in their city hall, right? So how is a municipal corporation injured? How do you injure Walmart? You can injure a personnel that works for Walmart, true, but still that injured party will bring a claim, right? You got the alien. We didn't hear nothing on him, right? He's scrambled, man. But
Islam.
Islam.
So I'm wondering, because I've had like something similar happen. Now, when dealing with things in like that realm and everything, shouldn't you like start with on the record, like telling them that you're here in your proper persona, and then asking them, well, not even telling them, but like letting them know you can't proceed until status has been duly noted. These are notes I have: for the record, in all matters of jurisdiction of this court are satisfied. And then I had wrote, ask for the request their delegation of authority. So when you're talking about delegation of authority, how does that play into these matters?
For one, you will want to have something in the court like weeks ahead of time, like whatever date that you're gonna make the special appearance, you want to have an affidavit, in an affidavit form, your position. And typically you're like what you just said, you're gonna be, depending on what you're trying to do, you're gonna either be saying, okay, since I'm not a citizen, we got manuals, we got Article 3, Section 2, which spells out how to deal with a dispute between two different citizens of two different nations. It spelled out how to do that, right? We got Article 3 of the Constitution, Section 2, which talks about is it the proper venue, essentially? And if it is, show that you got delegation of authority from Congress, because any court that's saying they're a superior court or anything of that nature, they're considered an inferior court. Because any court that's not Congress, any court that's not the Supreme Court is considered an inferior court. And any inferior court needs delegation of authority to even open up shop by the Supreme Court. And if that's the case, they need to have proof that that's the case. And it's typically hanging up on the wall, or it should be. So that's one. And then you got, like I say, from the Department of State, you're finna go into that actually, the Department of State Consular Notification and Access Manual, which is essentially codified Article 6 and Article 3 in the Department of State Manual on dealing with non-U.S. citizens that have, operate essentially like a consulate. So, so that's one. You can have paperwork in the court, and then once you get to the court, you want to reassert what you put on the paperwork that they got 2 weeks prior or whatever, a month prior, and then you want to reassert what's on the paperwork, as if, because you don't want to. You want to know what's on the paperwork. You don't want to just submit it and not know it, right? It's Islam Wardell. Happy Holy Day.
My shit on? Can you hear me?
Yeah, man. Islam.
Oh, man. I got my camera fixed on my phone.
That's what's up, man. Good to see you.
Forever.
Islam. But once you get in the court, just reassert what you filed. So let your filing be a study guide, so you kind of just know it off top, and the principles. And essentially, like you say, delegation of authority. I'm here, whoop-de-whoop whoop bay, I'm whoop-de-whoop L. I'm making a special appearance on the matter. I have paperwork that was filed. It was never addressed. I'm here just. You want to follow up with a default too. Just follow up. Your first affidavit be like, I'm giving you 5-6 days or whatever. No response, hit them with a default. And then when you show up, you're just addressing the paperwork, like what's going on, like based on remember what was it called? These principles of law, these matters of fact, right? That's the lingo, right? These issues of law, you know what I mean? Gotta, be addressed. And sometimes you can just get the magistrate information and be like, man, get on the calendar, like I want to just have a sidebar. And remember summary judgment? Remember what we learned last week? Summary judgment based on matters of law, right? And then if the affidavit competent enough, they might just let it go, especially if something nothing major. You know what I mean? So just try this stuff out. But did I answer your question?
Yes, Islam. Thank you.
So anybody has any thoughts on that last segment? All right. So I'm gonna yield the floor for Empress Lacey, and then when she's done on the back end, we'll have some miscellaneous convo. And Islam, I yield the floor.
All right, I'm gonna share my screen. Is that all right now?
Yeah, Islam.
Okay.
Everybody should share their screen if they want. They ain't gotta be in the shadows. Like you're
Oh, I meant like, so I prepared something, but it says host disabled participant screen sharing.
oh share. Oh, here, let me give you access. I thought you said show your screen. Okay. Let me see. Try now.
Okay. Yeah, that's perfect, actually. Okay. Everybody can see?
Yeah.
Okay, let me see. How do I view this? Oh, okay. So this is my summary of the book. I also have things that you've written in the book that I've included kind of like throughout the whole summary. And I'm just gonna like read it as we go. So Moorish tactical flow chart prepared by Grand Sheikh Mafiel. The importance of being competent, tactical, and strategic in your affairs as a national. You are not Black, Negro, colored, Hispanic, Latino, Puerto Rican, or Indian. You are a Moor, a Moroccan American. Learn and know this so you can get out of your denationalized state. Let me move this real quick. Okay, the problem is we started thinking like the colonists. So this is the book from beginning to end of what I got. Since the beginning, the North American educational system has been compromised due to the John D. Rockefeller General Education. Oh, that's supposed to say board, excuse me, curriculum of 1902. It was designed to keep the Aboriginal people of the land docile, which is actually in their mission statement. And we see that this is a big reason why we were led to believe we were shipped in chains on boats from Africa to America. Slave or Slav is short for Slavic, which refers to a European nationality and does not mean what we thought it meant all along, a state of servitude. Before there was a United States of America, there was 13 European colonies on the East Coast, which consisted of Slavs or slaves who are Europeans who were considered vagabonds, thieves, and scum to their prospective nation. These colonies were under the status of the European subjects and under the jurisdiction of their king or queen. Over time, these subjects started to rebel, and their acts led to the first Continental Congress, the Second Continental Congress, and the Declaration of Independence and the Articles of Confederation, when the 13 European colonies decided to form a union against each other. This European Union was called the United States of America, but we know that they were not the true Americans on this soil, they were Europeans. They had no protection and were refugees on foreign soil because they were no longer part of a recognized nation. This caused the European body politic called the United States to enter into a treaty with the original people of the land to receive sanction to remain in America. This led to the Treaty of Peace and Friendship of 1786 to 1787 that was signed between Morocco. And this treaty lays out the foundation of how to handle any disputes between the Moors, Al-Moroccans, and the United States US citizens. The true Morocco is the Americas. The Kingdom of Morocco was established in 1956 and is controlled by the French. The Moroccan Empire, consisting of North, Central, and South America, and the islands to West Africa. Is that Al-Andalus?
Al-Andalus.
Al-Andalus, Spain is much larger. Give thanks. So we now know that the transatlantic slave trade is a false narrative that was used to keep the Aboriginal people of the land, Moors, Moroccans, Americans, thinking they arrived on a slave boat. The history and events that transpired pertains to citizenship differences of US citizens and nationals. Now we know this and can focus on how to utilize laws in an organized, tactical, strategic approach. The Consular Notification and Access is a manual that is designed to help ensure that foreign governments can extend appropriate consular services to their nationals in the United States, and that the United States complies with its legal obligations to such governments. These legal obligations are primarily from treaties, which form part of the supreme law of the land. That is Article 6, thank you, of the US Constitution. And these instructions and guidance must be followed by all federal, state, and local governments officials, whether law enforcement, judicial, or other, insofar as they pertain to foreign nationals subject to the official's authority or to matters within the official's competence. Article 6 of the Constitution. This Constitution and the laws of the land of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary, notwithstanding. Article 6 is referred to the Supremacy Clause, and you must comprehend the dynamics of the clause and know that Article 6 states that any laws of any state to the contrary of the Constitution are notwithstanding, which means they are not law and they do not matter or pertain to you as a national. Article 4, Section 1 of the Constitution. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may be general laws prescribe the manner in which such acts, records, and proceedings shall be proved and effect thereof. The House HR 1203 that states that the Moorish Americans and Aboriginal and indigenous to North, South, and Central America, including the islands. And this lays the foundation that we are Moors. And once you know and comprehend that, you can introduce the Organization of American States, a binding contract that the United States is bound to uphold as a member of the OAS. Article 1, Section 2 of the Inter-American Declaration on the Rights of Indigenous People states, self-identification as Indigenous peoples will be a fundamental criterion for determining to whom this declaration applies. States shall respect the right to self-identification as Indigenous, whether individually or collectively, in keeping with the practices and institutions of each Indigenous people. You can use this article to enforce your nationality card. And Article 10 states rejection of assimilation. 1, indigenous people have the right to maintain, express, and freely develop their cultural identity in all respects, free from any external attempt at assimilation, which means no foreigner can make an indigenous person join or belong to an association, Department of Motor Vehicles, etc. If so, this would be a violation of Article 10. So my summary, was this thing here the whole time? I apologize if that was there. We must learn to relearn. We must study and fully digest this information regarding our nationality as the original people of the land. We must be able to comprehend laws, the Constitution, treaties, Inter-American Declaration of the Rights of Indigenous People, etc. Once we are competent, we can then be strategic in our ability to articulate our affairs as a national properly. That's Islam. That's what
Excellent presentation.
Islam, that was a great presentation.
That was beautiful. Wow.
Islam. Thank you.
That was well put. Like, that's damn near part 2 of the book. Like for you, like go ahead and feature that. That's hard. Good breakdown. Like that.
And once again, while we went through a Humble Bay, the Empress Phoenix, Empress Lacey did hers, and the whole point is, remember, when we're putting this information out to people that don't know nothing and we waking them up, remember, we need the people, because we the people, right? So they want to hear organization of thoughts, a presentation, right? Because that's going to show where you're at mentally. Can you organize your mind to convey a message eloquently, right? Because once again, when you say, especially if you're saying we Moors, that's a noble, illustrious history. All the sciences, preserving herbs and plants, linguistics, mathematics. So if we're saying that, then we're also saying that we're striving to be scholars, studious, well-balanced. Balance your mind and your heart with all your decision makings. Assess a situation, brainstorm, forecast, create unity, unite the people strategically, right? Based on the climate of the conditions of the times. So yeah, how everybody thoughts? How everybody feeling about the Empress dissertation?
Very well put together and very informative. And anybody at a basic level could go look up any of that stuff to go in deeper knowledge, but she gave a good basic definition of all of the points. Easy to follow.
Islam.
If I may, brother, I think if I must say so myself, I thought the presentation was beautiful. It's definitely answered some questions that I had. Taking this journey into nationalizing and continuing this journey of just learning. Right now, I'm a student in the game, and I'm just looking to soak up more information and more knowledge, bro. So I appreciate y'all for what y'all doing and for inviting me out.
Islam, yeah, that presentation was good, and like everybody was saying, it was hitting the key points of the book, like the things that that are most important that we memorize, and that's why I think it's a good presentation too, because I need to keep rereading that book, because that's the best way the mind learns, the repetition, and get all these codes down, numbers, sections, and articles and all that. It's good to just keep rereading it until it sticks. And yeah, one thing that was tripping me out too is how the Mexican people, like my mom and stuff like that, whenever she refers to to Europeans like Albions and stuff, she'll call them Los Americanos, son Americanos. You know, like they basically refer to the hybrids as Americans, and it just trips me out how we basically got conned to giving them our title. You know, the more I think about it, I'm like, wait, hold up, they're not Americans. But even my mom would kind of defend them. Oh, well, now they are, but it's just pretty deep stuff.
Yeah. Yeah, man. That stuff start popping out. Once you start getting the jurisprudence, and you start getting that measuring stick of what it is and what it ain't. You know what I mean? What's your nationality, man? Oh, I'm British, I'm Irish, I'm Dutch, I'm French. Right? So now we know the reason for those blurred lines, right? Because the school system, they're gonna teach what's advantageous to keep us in a political status of minority, which we know is a political caste system at the bottom of the barrel for people that don't know their culture, don't work together, don't trust each other, don't set up businesses with each other. They're into pseudo culture. That's the minority, non-cultured people. They want to keep us in that paradigm. So that's why, institutions like this is important. And I'm glad when new brothers, especially, pop up and say that they trying to get more info. That's a beautiful thing, man. Because expansion is key. And hopefully, like we read in the lessons with Yahshua, when you got the light, you're going to turn the dark place to a place that's not dark no more. And, pass that torch to somebody else and then bring them into a collective situation. Now we got a force field that's about 100, 200. One mind, one body. And them are small numbers. But it's efficient, realistic, and we can do something with that. Economically, intellectually, eyes and ears in different territories. And if everybody got the mind state, like this is not a club, this is not I'm just joining. This is we're the same nationality of people. And when you look around, all other nationalities of people, look how they conducted themselves. Look how they're prosperous. Look how they got, once again, heaven on earth, right? Our people got hell on earth, right? And it's based on customs, traditions, value systems, and the pecking order, of what's important to them based on the lack of knowing their customs, traditions in real time, which will create a humbling experience to even work with your people in the first place. If just knowing the illustrious history and the culture, you know what I mean? So, yeah. Anybody else got anything they would like to talk about in that vein? Before I jump off into a miscellaneous topic.
I just want to give thanks again for being here and also for the opportunity to put that together and, share it, because it really helped me as well go through the book again and read it. And I feel like it's kind of like, you might watch a movie one time, but the second and third time you watch it, you're getting other pieces, other gems that just stand out and make sense. And I give thanks for being able to publicly be here and speak in front of everybody as well, because I think this is an exercise we all need to do so we're comfortable in that essence. So thank you.
Wow.
Wow.
That's excellent. Just, you lead by example. You got out there and you knocked it out. You got the assignment a week ago. accepted it, knocked it out. You know what I mean? That's us. Tip my feds, highly respectable, you know, and especially from the empresses, you know, be able to just put that presentation like you did. That's gonna change the ethos right there, you know. So it's line for that. Anybody else have any thoughts? All right. So word there, we recording tomorrow? As a matter of fact, let me stop the recorder.